advice on this show. With me today, I have Gavin Ward, who has been on previous shows, but normally by telephone. So it's good of you to come in, Gavin. Welcome.
Good morning. How are you?
I'm good, thank you. Good, and thanks for accepting my last-minute invitation to come into the studio. I wanted you to come in rather than be on the phone, purely because I think it's we can get better information, more calls in as well. People are more likely to possibly ask questions if they know there is another person here beside myself. So, guys, if you have any legal questions other than criminal law, I think most other areas between Gavin and I, we can work it out. We got it covered. So, if you have any questions, please WhatsApp the studio on 07 440 420 432. That's 07 440 420 432. Or you could obviously call the studio on 01902 972 150. We like speaking to people. It is the best form of communication, I believe.
It's good to talk.
It is good to talk, yeah. So today's show, I decided to mix it up a bit, not go on my traditional route where, I'm going to be talking about this or I'm going to be talking about that. I want to answer your questions. Now, I do already have a few questions which people have asked, which I will put forward to Gavin, and I'll give a bit of input myself as well. But you guys are welcome to call or WhatsApp the studio with your questions. Now, let's start with the first question that I have, Gavin. So it's an interesting one. And in fact, this may be relevant to a lot of people getting married or who were planning on getting married. Obviously, people have booked halls, people have booked DJs, people have booked catering, people have booked, dresses and what have you. Now, a lot of these weddings have had to be either delayed for a year or maybe it's become a wedding which has now just been between the two parties and a couple of other guests or witnesses. So what happens in that instance? Gavin, I don't know whether you're aware, but Asian weddings are generally more than 300 odd people. So I think my wedding we had 500. So
I've been to a few and they're well attended. Yeah,
they are well attended. And some of the guests, the groom or the bride probably won't even know, but it's friends of the parents or acquaintances. Now, the first question that we have is someone's asked, can you explain what my rights are over deposits paid for suppliers? Now, I booked a DJ, so this person has booked a DJ. They don't want to name the DJ just in case they're listening. So everything went smoothly. I paid the deposit to book the DJ / dole services for my brother's wedding event set on the 2nd of August in 2020 for 30 people. On 31st July, Boris decided to make a U-turn and no longer allowed events of up to 30 people to go ahead. Since then, I have contacted the DJ to return my deposit as I have not used his services. He has said he will refund, but he doesn't. He has also now started ignoring my calls and text messages. It has now been a week of me trying to follow up with him. My brother is now getting a simple religious ceremony done, and that's it. We can't rebook or reschedule with him either. His services just aren't needed anymore. Can you please tell me what my rights are in this situation? As I said, a lot of people will be in this situation where they've booked and now they can't go ahead. So what are your thoughts on this, Gavin?
Well, My thoughts on this are that he ought to be able to receive a refund for it. He hasn't had the services, and he's not able to get the services that he would have contracted for originally. The Competition and Markets Authority have laid down some guidance on this via the government website as well. Their position is very much the same. So under consumer law, if you've not had the services that you've contracted for, you ought to be able to get that money back. They've gone a little bit further with the guidance on this as well, and they've suggested that if in the terms and conditions there would have been a non-refundable fee or deposit, then that would also be refundable as well in most cases.
Okay. Interesting. So you're saying
he should be able to get that money back, really. I think that's the way forward, and I think he's admitted that himself from what I can
Well,
tell.
he's offered it back, hasn't he?
Indeed, and if that's in writing as well, then he's accepting liability to refund that money. The reasons why he may not be contacting or providing the refund at this stage might be a bit more personal to his own finances. I'm not sure.
So maybe he's not got that money anymore, because obviously with COVID, a lot of people are stretched.
Yes.
So maybe his business is stretched.
He might be stretched. However, that doesn't prevent them from having recourse to small claims if they wanted to make a money claim online. And they will be able to then seek to recover that deposit. I imagine the deposit's within the small claims limit. That goes up to £10,000. So they're more than likely going to be able to secure a refund via that route. There is also a small claims mediation service in that process, which is free. And I'd recommend that they seek to use that.
The problem I see, though, Gavin, is all of these cost. And as you know, if the claim is below £10,000, then the costs aren't recoverable.
Yes, there's very much is a strict limit on how much you're going to be able to get back. And if this deposit's a couple of £100, then if you instructed a solicitor, you probably would only get about £60 of that back, I suspect. But the small claims route is relatively streamlined, and is designed more for litigants in person to deal with. And if you, say, have an email or a text message from the DJ that says that, yes, you're entitled to your refund, I will refund you the money, then really your claim form needs to indicate that and enclose a copy of it. And it should make it easier for you to secure that judgment. Indeed,
Right.
It might even be that you want to go down the summary judgment route if he tries to defend. But then, again, that's cost, and costs that probably wouldn't be recoverable. And you're also probably getting into complexities there where you might want a solicitor's advice, potentially, or maybe a little help with drafting.
Right, yeah, very true. Now, guys, if any of you or any of your family members or friends are in a similar situation and you have any further questions to what we have now just mentioned and discussed, please give us a call on 01902 972 150 or text us via WhatsApp on 07 440 420 432. We'd love to hear from you. Right, so that was a good one to start off with, wasn't it, Gavin?
Yeah, I think there's going to be, as you say, there'll be a lot of problems with that, and that'll be for a lot of weddings across the board, won't it? Where there'll be a lot of suppliers that are going to be struggling themselves, will probably be quite slow to refund, a bit like the holiday companies have been with their refunds to customers. I suspect Ryanair's probably still in a backlog situation with theirs. I can imagine this being quite a widespread problem that people will have. There are a few other options which they might want to consider as well. So if it was paid for by a credit card, they might want to consider a Section 75 chargeback there.
Oh, yes, yeah, that didn't come to mind. Well thought of.
And that could be done through the card provider. There are some similar-ish protections with debit cards as well, but there are differences there to take into consideration. Your better protection is with a credit card. So if you're going to book something like this and it's not going to be provided, book it with a credit card, because you might find that you get a better and quicker and cheaper response by dealing with it through your credit card provider, who can effectively, once you put the claim in, can recover the money back from the other party directly and will refund it back to your card.
That's brilliant. I've actually just thought of a point as well. I've recently tried to pay most of the things. Obviously, there's been a lot of online buying now. So I've tried to pay a lot of things by either a credit card or PayPal.
Yeah.
Because PayPal also have a time scale in which you can claim back if you think you've been wronged.
Yeah.
And I've had to put a claim in, which I did on Friday actually. Now, I saw this advert online about this jet wash type of thing. I thought, well, that's nice, that's good. Let's buy it. So it was slightly on the cheaper side as well. Not, but I'll go into the next part. I received something 2 months later, so it transpired it came from China, and what they sent me was the end of a hose pipe. You know, the attachment.
Yeah, the head.
Yeah, the head. They sent me that. So what? 50 pence, and I think I'd paid about 40 odd pounds for it.
Oh.
So it wasn't a jet wash per se, but a cordless thing, which is like a jet wash. So, yeah, I contacted the company and said, first of all, I contacted them saying, "No, I've not received it yet." I said, "Oh, yeah, here's a delivery notification." I checked with the wife. I said, "Have we received a parcel?" No. And checked with our post, and there was a little package there. I thought, right, what's this? And that's what it was.
And it wasn't what you were expecting at all?
No, not at all. Not
Did
at all.
it conform to the pictures at all?
No.
It looked like you had a proper jet wash, but you actually received
no, exactly. So
if it doesn't meet its description, then
well, I've emailed them back, and at the same time, I've obviously put in a complaint with PayPal.
Yes.
And let's see what happens there.
Yeah.
So
watch this space.
Exactly. I've got a couple of other questions here for you to discuss. In fact, we've had someone send something in just now as well.
Oh, okay, that's excellent.
Oh, it's actually very similar to one that I had during the week. So it's Assalam, Ajaz and Gavin. Walaikum assalam. Can you advise me? I have a boundary issue with my neighbor where he has erected concrete posts and fence panels on my side of the boundary. I have approached him to rectify many years. All right, I guess it's for many years. But he ignores my conversation and letter requesting this. Apologies, I can't ring in as I'm at work. Right. And then there's photos. Gavin, I can't share the photos with you.
Sure.
Obviously, they're on my screen.
Of course.
The concrete post is on my wall. Okay. He also has a fence panel missing that he never has put up, and his shed is visible. Right. So, boundary dispute.
Yeah, but basically it's a boundary dispute, and if it's on this individual's who's called in, or should say has messaged in, if it's on his land, then he's got the right to move it.
Yeah, but I suppose we also need to establish first of all whether it is on his land.
Yes.
Where the actual boundary is.
Yes.
Who's responsible for that boundary?
I suspect the other side will suggest that the boundary is where the fence is, and there is an argument over the exact position of the legal boundary.
Yeah, we see a lot of cases like this, don't we?
Yes, you see a lot of cases like this where it's not necessarily fully defined. That's why in a sort of a recent matter that I'm dealing with at the moment, I've suggested where they're readjusting the legal boundary to suit, and both parties are quite happy to do so, there is a measured plan, so you know exactly what you've got from boundary to boundary in that, and there's no further argument in the future on that point, or at least a very restricted argument, if there is one.
Yeah, now, with this, I mean, the photos I can see are... I can't see whether the boundary is in the middle or not, whether this fence is in the middle or not, or whereabouts it is. All I can see is next to a drain pipe. So really, I can't comment on that without actually seeing, the boundary line, so to speak. But I would first of all check your title documents.
Yeah, the title plan will be very important.
Title plan will be important, yes. And if it's an older property, you'll see on the older deeds, because the new ones may not have it. On the older deeds, there may be T markings on the pictures, and to show whose responsibility that boundary is. if it appears that it's the neighbour's responsibility, then your argument is purely, is it in the right place,
Yes.
as opposed to has he put the right boundary up? So what this gentleman is saying is the fence is in my land. Okay. Why did you let him put it up?
Well, this is it. I mean, then again, I suppose he may not have been present at the time when
Whoever the person is, they are actually typing as we speak.
Oh, excellent!
I can see.
So we're going to have a live chat on this.
Yeah, we're having a live chat. So, yeah, why it's attached to my detached property? Okay, interesting. Has that fence been there for some time? Has it been there before you were there? Has it been there? Did you give, or if not, did you give permission for it to be put up there?
Is there a risk of adverse possession?
Or did the previous owner give permission when we are not present? So are you saying you were, apparently he put it up when they weren't present. So you allowed the fence to be put? I have a conservatory. Okay.
It sounds like one for a potential site visit and check-in title.
Yeah, exactly.
Like that,
this
really,
is I don't think this is something that we can really go into that much depth, other than saying that without having sight of the boundary line, we can't really say, and obviously the title documents, say whether this is on your boundary. But if, for instance, Gavin...
You probably need a surveyor as well.
Possibly.
To check that out.
Yeah, but if it was... If, as this person is saying, if it is within his boundary, then what?
If it is within his boundary, then he's got the right to have that moved. I mean, it's his land, and it is effectively blocking off a part of his land as well. If it's on there, because he's effectively, the other chap's widened his garden to accommodate himself, which isn't strictly permissible. So that needs to be moved to where the legal boundary ought to be. Now, the documents are going to be very important for that, the title plans, to show where that is. I would suggest that a surveyor is going to be necessary to be able to work that out, to define the legal boundary. If you have a reasonable relationship... I
suppose it also depends on how far into his boundary it is. I mean, if he is a detached property, as he's saying, or he or she is saying,
yes,
and this fence is basically connected to his building, I find that there may be an issue there. That property, the neighbour must know that their boundary doesn't stretch that far.
But then again, some people do put things slightly out, not necessarily realising it. It may actually have been the contractors who just went, oh, well, it's around about here, and that may have been, I don't know, 10 centimetres difference from where it ought to have been. And we could be talking about a relatively small amount of distance, and the contractors might have put it there, and the other side's just gone, well, it's there now, I've paid for it, I'm not paying for it to be moved again. But obviously this person's aggrieved because it's taken a dredge of their land, albeit small or albeit large, depending on how big it is.
Now, I'm not sure whether we're allowed to mention this on air, but the gentleman or the lady has asked, can I have your contact details to address? Well, if you put my name into Google,
yes,
it's Ajaz Ali. I own a local law firm, so you can find my details on Google. My firm is in Wolverhampton, in Tetnall. So we can address that for you as and when you wish.
Absolutely.
Right, moving on. An interesting one that was.
Yes, very.
And again, guys, if you have any other matters like this that you'd like us to address, I'm happy to go through it live on air or discuss it with you later. But come on air and let's have a discussion. The number to call is 01902 972 150. And if you want to just message us with your inquiry, legal inquiry, I'd say, it's 07440 420 432. Look forward to hearing from you. put the charges on him to sort through legal matter as it's his fault. That's a question. So the person is asking, so if they have to go the legal route,
Yeah.
what would happen as far as the costs? Would they be able to put it on the other side? I suppose it's the same as any other small claims.
For instance, I dealt with a party war dispute last year, and it was all pre-action stuff, so you weren't in court with it. There was threats of doing so and such, but it ended up getting resolved with a surveyor in the end. Pre-action, no issues there. You can't really claim those legal costs back from the other side. You can request it, but unless they're going to agree it, it's not going to happen unless you're issuing court proceedings, and then you sort of press in for costs. In that way, you've got more right to do so then.
So, yeah, there's your answer. And, we'll move on to our next question now. We've got just over 4 minutes before we go into a break. Let's see if we can address one. So the next question that I have, Gavin, it again relates to boundaries, really. And the gentleman whose inquiry we just dealt with, a lady we dealt with, slightly is different to that. We do have another question later on, which is similar to that one. Anyway, hi, all I need is some legal advice on a shared drive. We've moved into our home 9 years ago. Our neighbor is lovely, but she claims the shared drive belongs to her. We have a side entrance to the garden, which has to be accessed from the shared drive. Access on the shared drive. Last year, we spoke to her about having the shared drive blocked off, no expense to her, as I have a son with additional needs and he runs off onto the street and we cannot open our side door to allow airflow on hot days. She refuses as she was planning on selling her property. I have checked our deeds and that shows that the boundary is as we expected. It's half and half. She claimed she contacted solicitors before we moved in to confirm that she owns the land. She claimed that if we needed to use our garage located adjacent to hers, we would have to ask her permission. And then they've given a photo as well. Now, to me, well, I'll let you give your opinion, and then I'll give my penny's worth.
Yeah, absolutely. You really do need to look at the title documents for both houses to see exactly where the legal boundary does sit. So, judging from the small message that's here, it's suggestive that it does sit down the middle. Presuming that is the case, you would expect that there will be probably easements of access over the driveway, probably on a mutual basis to allow both parties to access their garages at the rear of the property. So I don't think that they would be okay with blocking off part of the driveway there. I think there would be an issue with that if the neighbour wasn't happy with it, albeit there might be some other changes that they might be able to make to allow them to open the side door and say, protect from their child rushing out into the street. But I would have suggested there that they should really check and see who owns what land and what the easements say in terms of access first before making any particular decisions on it. But I would suggest that they probably both have access across the driveway to be able to utilise the garages. And I would be quite surprised if they did need to ask the neighbours' permission to be able to access their own garage at the back.
Okay, cool. Well, we used to own a property which was similar to this, where the neighbor, funny enough, I say we, my father, funny enough, the neighbor again put a chain across the front to block the drive. At that time, we used to live in this property a while back, and then we moved out and rented it out. And the neighbor put a chain across saying, oh, she doesn't like the neighbors, our tenants, parking there. Now, again, this was a shared drive. Ex-council property. So what I established was that it was 50-50. However, as you mentioned, we had an easement on our property, and she had an easement on her property, so that we could each use the full drive.
Yes.
So I'm assuming that there will be a similar situation here.
I imagine
and
so.
from the photo, which maybe you've not seen, but it does look like an ex-council property. So the layout seems very similar.
I have seen the driveway. It looks like it narrows as it heads to back, and
That's
if the
right.
garages are at the back, I would expect there to be shared easements there.
Guys, we'll be back after the break. Thank you. Assalamu alaikum. Welcome back after the break. I was discussing with Gavin before the break. I was discussing with Gavin a matter that I've had a question on in relation to a driveway, shared driveway. Now, as I said, I've been in a similar situation myself with my family, and obviously that's resolved. It helps the fact that I'm a lawyer myself. So yeah, moving on from that matter, Gavin, there's a few other matters and which I've had questions on, which I'd like you to put your 2 pence worth on. Yeah.
Absolutely.
And before doing so, guys, if you have any questions, I know I've repeated this a few times today, but I want the people of Wolverhampton and wherever the listeners are from in England and Wales to take advantage of myself and Gavin being here for you. Any questions you have, legal questions other than crime, please give us a call on 01902 972 150 or text in on via WhatsApp on 07440 420 432. Thank you. Right. Moving on, Gavin.
Sure.
I think someone's trying to call via the WhatsApp. We can't take WhatsApp calls, I'm afraid. We can only take telephone calls or WhatsApp messages. So, guys, whoever's trying to call, please don't call on WhatsApp. Message on WhatsApp or call the studio on 01902 972 150. Right. So next up, again, there's a lot of boundary issues that are cropping up nowadays. I suppose with people being in lockdown and staying at home,
they've noticed.
They've noticed issues with the neighbours, or they're having more. I was saying in a few shows ago that with people living together, I was talking about mental health, and with people living together, more chance of you arguing if you're with the person 24/7.
Yeah.
So here, because you're in in the vicinity of your boundaries, now the boundaries are an issue.
They're not big enough.
They're not big enough. Yes. So So this next one is: can you advise on this? Neighbor overgrown sycamore tree. I've tried routes. I talk and reason with neighbor. Written letter, text message. The problem. His response is, You should have not built the extension. He has refused to compromise on anything. We offered to cost and replace tree and have even asked if you can just maintain the height as it's causing issues to my property. Complaining to the council. However, because the tree is not listed on a list of trees, I'm assuming they're talking about a tree preservation order there.
Yeah.
Where they can take action, they cannot assist in this one. The tree is causing blocks to gutters and drains, and unattractive mess on the roof. Lantern. Any professional advice or other routes I can follow would be appreciated. I understand that I am entitled to cut back branches to my boundary. However, the sycamore may grow back aggressively. This may be a continuous cost to me. Any advice, please? And there's a photos of the sycamore tree there as well.
Yeah, and some of the debris in the gutter.
That's correct.
And on the skylight there as well. Yeah, so it is a bit of a shame that they're not being reasonable enough to at least maintain sort of the height and the side of it, so as to try to at least minimise the problem as much as you can.
Mm-hmm.
I mean, it effectively, if it's a tree on their land, then it's causing a nuisance to you, then there is potentially an action in nuisance there if you want to take it. It might be that you're looking for a solicitor to write a letter to them, just highlighting the issues and perhaps a sensible remedy of just having the tree's height maintained and making sure that it is appropriately, the branches are cut so they're not overflowing into your garden, and just just trying to minimise the problem as much as possible, but also noting the potential risk of a nuisance action against them if they don't do something about it. I also wonder whether or not it's possible to have the tree popped on the council's list if the council's able to then do something about it.
I don't think a sycamore tree would be, but you never know.
Yeah.
Now because it seems quite a new tree. It doesn't seem like something that's been there for
It looks reasonably young, doesn't it?
Yes, exactly. Now, the other thing that I've just thought of it, they mentioned that they know that they can cut it back. So once they do cut it back, those branches that they cut off, who do they belong to?
Well, ordinarily in these circumstances, you would allow the neighbour who owns the tree to have those branches back, and it's usually that neighbour's responsibility to dispose of that garden waste, and it shouldn't be for the person having to cut it back to do that. I mean, we have trees at the back of our garden. They usually get pruned and chopped once a year in around September. We offer to the neighbours on both sides and the back to do the same. The ones on the back don't like us doing it. They're happy doing it themselves, but they've had that option. And we always offer to take away the garden waste from it as well. And that, as far as I understand, is the position that neighbours are expected to take on it. If it's your tree that's interfering, you should be clearing up after yourself as well.
Yeah, well, we've had a similar matter next door to us. Not next door across the road from us. So this gentleman, he cut back someone's tree, his neighbour's tree, which was overhanging onto his drive. And so many branches. There's so many trees there. It's quite, the whole back is covered with trees.
Yeah.
So he's cut them back. And then he says, what should I do with these? I forgot a tip. I did say, well, technically, it's their responsibility. So I think what he did was he just threw it onto his land and said, here, deal with it.
Well, we did have a similar case a couple of weeks ago with a neighbour dispute, and they were removing something that was growing on their boundary line, and that had to be, the neighbour had chopped it off, but was throwing it down into the correct neighbour's garden, but was throwing it in such a way that was causing damage to other plants in the garden. Now that's an attempt at actual property damage in their garden, and you should always avoid trying to do that. Be neighbourly about this. Yes, it might be their garden waste, but don't make the situation any worse than it has to be, really. Be fair, be neighbourly with one another. It will avoid disputes. Yeah.
So, that's the advice there, guys. Again, if you want to call in, 01902 972 150. Text on WhatsApp 07440 420 432. Shall we move on to the next question I have here?
Yeah.
Now it says, I'm looking for some advice regarding my back fence. So this is, as I said, was similar-ish to one we've discussed earlier.
Yeah.
Where the gentleman or lady text in. It says, we have checked the deed, and it does belong to my neighbour, who is a landlord. It fell back in December 2019, and it still hasn't been fixed. I understand legally that there just needs to be a boundary line, but what grounds do I have of my toddler, if my toddler gets injured due to the fact that the landlord isn't doing anything about it? Just to add, for clarity, landlord has been contacted on 3 occasions and twice made up excuses that she was out of the country, weather is bad, and third time has refused to respond. The tenants are a nightmare, do as they please and have no consideration for neighbours. Please see the pictures attached. So we've got pictures there as well of the fence. That they're interesting pictures, actually. The fence, one is fallen, the other I can see some.
I don't know what that is, to be honest.
Concrete or something.
It does look like concrete, doesn't it? A lump.
But a huge lump, isn't it?
Yeah.
So,
I mean, was that a footing from something that's been pulled up, or?
Does it look like it's attached to something, that black thing attached to it on the side?
Yeah, I mean, or maybe if you look just above there, it might well
Could it have
be
been
something sticking out of it. And
could it have been a footing for a post?
I think it might have been, yeah, and it might be, say, high winds or a bad storms pulled it
Or
out.
or could it be that this has been put in on their side if the ground is higher on the other side? If
Yeah.
the neighbour's ground is higher than this side, then maybe it's they've put some kind of footing in, which is obviously looks quite a mess on our guy's side, but maybe ground level on the other side. I can't tell so much.
Yeah, it might be sloping upwards as it goes.
Yeah. Anyhow, that is what it is. So, what's your advice on this then, Gavin?
So I suppose there's two points, isn't there? So there's been reference to the legal boundary not having an appropriate fence on it, but it is the neighbour's land. So it's not his land, it's not his fence to be able to deal with it. So he needs to be able to get them to sort that out. What I would say is you might have some difficulty with the landlord there, where you need to you need to similarly address it in a way that we talked about.
Yeah,
with
like
the last one.
Exactly.
Really contacting them probably via a solicitor actually on that.
Well,
one,
if they're not
highlighting-
listening to communication between yourselves, then I suppose legal route, maybe, if nothing else, might scare them into taking action.
Exactly. One letter might be enough just to persuade them to actually deal with the fence issue there, particularly if you're making reference to a toddler that might incidentally cross over the legal boundary, might get hurt in the process because it's unkept, and it could trip over that fence panel and injure themselves, and there's an Occupiers Liability Act action there potentially for the toddler. But yeah, absolutely. You'll probably be wanting to contact them and just sort of suggest, is there a nuisance point there to consider as well?
Another point that I just thought of, well, if it's a problem for them and it's not something that can be resolved immediately, considering the weather nowadays and people being confined to their homes, and the toddler may need to be out in the garden, could they not do something as a temporary fence, themselves?
I think
obviously
they could
on their own land.
They could do something like that. They could put up a temporary fence across it. They could even take that board. I mean, I don't know if that's lying on their garden or if it's lying on the landlord's garden. If it's lying on their garden, then they're fully entitled to remove that and actually reposition it on the legal boundary themselves.
Exactly.
And that would probably do the trick. And if the landlord, frankly, can't be bothered to get involved, then if they put that back up, then it won't be perfect, but it'll at least be a temporary fix, I suppose, which will stop the toddler from then creeping out of their garden into the neighbour's back garden, particularly if the tenants are a bit of a nightmare.
And save them from all that mess there. On this one, although it may be the neighbour's responsibility, the landlord of the neighbour's responsibility, we would say that you could take legal action. But in the interim, it's probably advisable for your own safety, for your child's safety, to just prop it up. Right. Moving on, Gavin, I have another client's question. He said, I am looking for legal advice on the following matter. I own a freehold warehouse with shared access. In our block, there are only 2 warehouses. On the front of our boundary of warehouse, we have empty land which we have rented out as a car dealer. Oh, this is going to be an interesting one, isn't it? Mm-hmm. Now, land next door is making the fuss and says she will inform council about this car dealer and will not allow us to sell cars.
Okay.
She has also threatened us today with legal action. My question is, where do we stand with this situation? I believe it's our private land and we can do whatever we want. Any thoughts, please? I think the first thing that comes to mind is
permitted use.
Permitted use. Is there planning permission for a car lot?
Yeah.
The next thing that comes to my mind is it shared?
Yeah, and if it's shared land or a shared accessway of some sorts, and you're going to be putting a lot of cars on there for sale, then you're going to be blocking that access up, and there, there's going to be a potential right for them to ask you to remove all those cars to allow access to continue.
Exactly.
If it's not a case of access and it's just a case of it is your private land, but you want to use it for a car lot, that's fine, providing you've got the permitted uses in place from the council to be able to do so. It's worth checking that to see what your current permitted uses are, and then applying appropriately to the council if you need to apply for something new.
Yeah, I agree. I just want to do a little shout out actually. I've just seen someone online, Ninda Johal, the Deputy Lieutenant of West Midlands, is watching us. Hi Ninda, glad you could join us. I'm sure I want to get you on one day. In fact, if you have time, I want to discuss your new roles and also your new business magazine. Looks like a brilliant thing to actually bring onto our show and discuss. So I should be in touch with you at some point. Moving back to the issue at hand. Nice guy. You should meet him at some point.
His name's very familiar. Did he used to work at Dudley College of Technology?
I'm not sure.
As a lecturer?
I don't think so, but Ninda's had his hands in many pies. I don't know. Maybe he can put a comment up and let us know.
If he did, he may have taught me in 1999.
Oh,
so
right.
2001, potentially.
Right, okay. Well, that's one for him to answer at some point. Right, yeah, moving back to this. So, yeah, I feel that the person asking this question may be in the wrong. And there may be issues that as planning issues.
Yes, I agree.
And also issues in relation to, as you said.
What they might want to do is potentially fine as long as they've appropriately planned for it.
Exactly.
And properly accounted for it and have checked what the land is supposed to be used for. And as you say, that could be access rights as well as planning and permitted uses. So they definitely will need to make sure that those are ironed out and right first of all. I suspect that if they do make an application to the council for a change of permitted use, said neighbour that doesn't want them to do it will no doubt be objecting to it.
Yeah.
And then there'll probably be a bit of fight in terms of planning on that as to how that's going to look.
Possibly, yeah. So I would move into, basically check your planning rights.
Yes.
Right. So moving on then. You mentioned a matter to me earlier on that you have recently been dealing with. I don't know whether you want to discuss that in brief. I suppose you can't go into the details. The one with the property which was on someone's name but not on their name, so to speak.
Yeah, so we've certainly had a very interesting one recently, whereby there was a conveyancing transaction which took place a couple of years before between parties. There were, as far as we know, there was a willing seller and a willing buyer there. We found out that the apparent willing seller apparently didn't have the capacity to sell, but also didn't get legal representation in terms of the sale. The buyer did. The property was appropriately transacted with the land registry, and the names were changed over, and the seller was given the right to live there for the rest of his life. From that, the local authority had intervened. There was quite a considerable case there, which reversed the transaction and attempted, insofar as it was possible, to reverse the financial element of the transaction as well. However, that left our client out of pocket and actually with an order saying that the house wasn't his.
Yeah.
So that put us in put them in a very difficult position, and they wanted to rectify that situation. Since then, unfortunately, the alleged willing seller had passed away, and it's now for his son. His son was involved in the original transaction and actually was the sole beneficiary of the proceeds of the sale of the house. So a risk had arisen that he would become a sort of have a double benefit there of being able to sell the property twice and take the money twice. Various issues which we won't go into in relation to that individual, but he's been supported by solicitors to be able to deal with his father's estate, and we've been working closely with them to ensure that the original financial transaction that took place is put back in place.
So that your client is then made whole again, yes?
Yeah, so the client is then made whole again. They get the property, and the son will receive back the money which was initially returned via a freezing order a couple of years ago.
So ultimately, good result for your client if you manage to pull off what you're trying to do.
Solid result for him, and at the moment everything's pointing in the right direction. So we're very happy with that.
And I believe there may be another claim for him out of this.
Yeah, potentially. It comes down to his solicitor at the time hadn't necessarily fulfilled all of the necessary obligations that you would expect from a purchasing solicitor.
Mm-hmm.
And as a result of that, and I won't go into the wheres and why-hows of it right on here, but that could lead to a claim via the Solicitors Regulatory Authority's Compensation Fund to allow our client to recover his fees back, which he has lost out on, both in the original court protection matter, but also in the matter which he has expended costs on trying to get the property back via us now. It's a considerable sum of money, and it would go a long way, I think, towards helping him renovate that property, or indeed, at least a deposit for another one if you want to buy another one.
Yeah, well, great. I'm glad you're doing some good work there. So, guys, we're coming to the end of our show now, with only a minute to go. I want you guys to contribute in relation to the areas of law that we cover. Any legal queries that you have, you're welcome to WhatsApp them across to the studio. And the studio, even if I'm not here, will forward the inquiries on to me, and I can then make sure we have the appropriate advisors on the shows with me. So if it's something I can't cover, I'll make sure I have someone with me who can cover that area of law and give you the right advice and give you guidance, I should say. So if you want to text in throughout the week, you're welcome to. And I'm sure my co-presenters will be happy to forward those messages on to me. The number to text is, WhatsApp text is 07 440 420 432. Look forward to seeing you guys or speaking to you guys again next week. Allah Hafiz.